Good afternoon or good evening. Welcome to Chapter 3, Essential Elements of a Crime. This lecture will be pretty closely following most of the major points inside your text. I will have a few additional subjects I want to bring up, or points I want to bring up, primarily focused on how North Carolina treats some of these issues, but it's going to be pretty similar to what you see in your text. Okay, first and foremost, we start off with our learning objectives. These are pretty common. You see them in almost all of the chapters that we cover, and really they're just broad themes we're seeking to look at. You don't have to know them specifically, although they'll probably help you study at some point. Just kind of stick them in the back of your mind for a while and move on to the regular slide. So your book starts with conviction of a crime. And of course, we should remember that before there can be a conviction, which presupposes a trial, there has to be an arrest. And the standard for arrest for the presentation of evidence is, I guess, the lowest of the standards we're going to talk about. That's probable cause. Can a police officer say that it is probable that an individual committed a criminal act? Now, it doesn't have to be 100% certain. Police officers aren't perfect. One of the things that our system does is it oversees what they do. So once a police officer is convinced, beyond a mere suspicion, that it is probable an individual has committed a criminal act, they're brought into custody. Then they're entering the court system. Now, assuming this is a criminal trial, and it will be after an arrest, the standard of proof we're going to use in the courtroom is proof beyond a reasonable doubt. Now, it's not just that it's possible that the individual is guilty and that whatever element or elements we're seeking to show are true, but that a reasonable person would believe it is true beyond any reasonable doubt. Now, civilly, we use a different standard. Civilly, we use preponderance of the evidence, which is a little bit more lenient. Your book says it means more likely than not. This is an inexact way of looking at it, but you could look at it this way. Civilly, I have to prove 51% to 49% that someone is liable, but criminally, you've really got to come forward with substantial evidence to prove. Now, you will also sometimes hear a different standard, a standard between preponderance and reasonable, called clear and convincing evidence. That's primarily an evidentiary standard for certain things like sometimes insanity. So we're not going to deal with that too much, but if you do run across it, just be aware that there are standards between the civil standard of preponderance of the evidence and the criminal standard of beyond a reasonable doubt. Okay, the next point is talking about essential elements of crime. Is we talk about the three vital parts of all crimes and how they fit together. So we talk about the idea that all crimes have to be physical acts. All crimes have to be coupled with a mental state, an intent, and all crimes should have both of these together, knowledge. Now, we use Latin names, and we use a rather obscure term for the third element. So we use the terms, and we're going to look at these in more detail in just a minute. Actus, Reus, Mens Rea, or Mens Rea sometimes, and Scienter, which is knowledge. So you're going to have both of these, the physical and the mental act, together to have your crime. Thoughts by themselves are not crimes. I can think bad thoughts about people. I can wish someone is dead. I could wish that a building was burned down. But that's not a crime. Neither is an accident. If I was smoking a cigarette and threw it out in the trash can and it caused a fire, and the fire burned down that building, that's not a crime. It might be negligence, but it's not a crime. Now, there are a few cases where we have exceptions to this. There are some crimes without mental fault. There are some crimes where it's not what you do, but what you don't do. And then there are some crimes that don't require knowledge. And we're going to look at each of those large exceptions after we address the first few points. Okay. The forbidden act, which is actus reus, actually the physical act of the crime. So each crime, if we take a crime that's defined, let's take first-degree burglary in North Carolina. The physical parts of that crime are as follows: that you break, which means to literally create an opening, and enter, placing some part of your body inside. And now it's not so much an act, but something associated with the act. An occupied dwelling at night with intent, that's going to bring us to that really second part, to commit a felony therein. Now, one of the things that your book does here is it says there could be different parties to a crime, and that's absolutely true. What it doesn't do is use the typical names that are used inside the law. So when it says in this slide, a party to a crime would be one, the person who actually and physically commits it, we generally call that person the principal. Two, a person who conspires in the planning of a crime or orders that crime to be committed is usually called a conspirator, excuse me. And three, a person who aids and assists is called an accessory. Now, most crimes are crimes of commission. You actually do something. You stab someone, you shoot someone, you burn something down. Most of the time, not acting is not a crime. There are a few, however, again, let's use a North Carolina example, where a parent failed to feed or care for a child. Now, they didn't actively hurt the child, they didn't beat the child or stab the child, but they didn't feed it or give it water or take care of it. That would be a child abuse. That would be a crime. Depending upon the injury, it might be a felony child abuse. Okay, these failures to act, which is not terribly common. They become more common in the 20th and 21st century, but when the common law is developing, there's not a lot of duties. But here are some examples. Failure to report death of a child, failure to report location of human corpse. Here's that child abuse one I just talked about. Failure to submit to a breathalyzer. Failure to remain at the scene. Homicide by omission, which is homicide by failing to do something. Failure to act in a contractual agreement and a person is harmed. That's usually not a criminal act per se. Okay, so we've talked about commission, we've talked about omission, which really covers our actions. Let's talk about the state of mind, the guilty mind or mens rea. Now, in most criminal codes, if you have a physical act, you've also got to have the mental state of mind. And very often there are different degrees. So sometimes we'll say, you know, if you're going to commit first-degree murder, you have to commit the crime with you have to predetermine it. You have to premeditate it. And that could be shorthand for that first one. You purposely kill someone. Then there's knowingly, recklessly, negligently. And if we apply this to homicide, it would move us down the scale of the different homicides from the first and the second-degree murder down to the voluntary and then finally the involuntary manslaughter. Now, it has to be shown that someone had the requisite state of mind, but it's really not subject often to the same physical proof requirement that you see for the physical act. And we're going to get a very nice slide here, which is going to show that we start off with simple negligence. And if it's not severe enough, it's usually civil, so an accident. But you can have criminal negligence where you really messed up quite a bit. Recklessness, knowingly, and then specific intent, which is intentional, willful, or purposeful. The higher up you get that, typically the higher the penalty and the more serious the crime. So if we look at our homicide statutes again, first-degree murder would be at the top with specific intent and premeditation, and your involuntary manslaughter would be down to the bottom. Now, specific intent means, that term we've been throwing around here, that the party intended for the desired act to occur. I take a gun, I point it at Fred, I pull the trigger, I have the specific intent to kill Fred. So that's a first-degree murder charge. On the other hand, I'm playing around with a firearm and the firearm goes off and shoots someone. Well, we all know we shouldn't play with firearms. I didn't intend for that person to be shot. Nonetheless, I could probably be charged under general intent with assault with a deadly weapon inflicting serious injury in North Carolina. If whatever level of intent is part of a crime, then the prosecutor has to prove that. Now, there can be cases, and states are free to create those cases, where there is no requirement of mens rea. So we come up with a substitute. The U.S. Supreme Court has never said that it is an absolute requirement. So there are a couple cases, some fairly rare, some pretty common. For example, in North Carolina, we have the murder felony rule that is an exception. Basically, if I'm committing certain felonies and someone dies, even though I had no intent, no mens rea, no evil mind, during the commission of these crimes, that'll constitute a first-degree murder. We also have crimes which are strict liability crimes. We don't care what your mental state is. And an example there would be speeding. You might not even know you were speeding, so you had no awareness of it. But we don't care. We just say, what were you doing? What speed was it? If it was above the speed limit, you've got criminal liability. Now, Senator is not used in all texts in the same way that your text is using it here. Basically, that Senator says you know, sometimes you see for the term you were lying, you know you were lying, but you can also use it generally of you knew what the facts were and you went ahead anyway with knowledge they were illegal. So if I'm going to charge, let's suppose someone comes at me and I hit him in the head with a 2x4. It turns out the guy's a cop. Can I be charged with assault on a law enforcement officer or public official? Well, no. If I didn't know he was a police officer, it's just going to be probably assault with a deadly weapon, potentially inflicting serious injury, which is bad enough. But you can't tack on law enforcement. And then if someone identifies themselves, says, I'm a police officer, well, now I have knowledge. If I swing the 2x4, now we're at the assault with a police officer. Receiving stolen property. If you're running a pawn store, or your friend comes up and says, hey, would you like to buy this laptop? And you say, I didn't know you had a laptop. And he said, oh, yeah. You know, I got this a while back, but I don't want it anymore, and I'll sell it to you for $100, which is a reasonable price. Well, then, if you didn't know it was stolen, it could be difficult to prove receiving of stolen goods. Now, of course, you can't be willfully blind. If someone comes up to you and says, I'll sell you a laptop for $5, you've got to know, in all probability, that that is stolen. So you would be guilty of receiving stolen property. Now, Senator can be introduced by using different language in statutes. As I said, you can't defend yourself by just saying, well, I had no direct knowledge. So sometimes you will see what's called the willful blindness rule. The trial judge will tell the jury, you can say that someone has knowledge, that they have Senator knowledge that the good was stolen, if they made no attempt, really, to find the truth. Now, the Supreme Court has upheld this, and they say that willful blindness will serve as a substitute for actual knowledge if you believe there's a high probability, or if the defendant took deliberate actions to avoid learning. Essentially, then we create a strict liability situation like speeding, which I talked about before. Knowledge and purpose types of means of mens rea are very similar. So you can look at like United States versus U.S. Gypsum Company, where the United States Supreme Court stated that in most crimes, the limited distinction between knowledge and purpose has not been considered important. So purpose and knowledge are often treated essentially the same. All right. Now, I often get a question about motive, and I'm glad your text and this PowerPoint included a slide on motive, because you frequently hear TV programs or movies, people talking about motive and is it important. Well, very often motive is not part of the what needs to be proved. Now, sometimes people think, well, intent and motive are the same thing, and that's usually there's some connection, but it's not always. Intent is your purpose, motive is your inducement or cause, and you can see how close that is. You almost never see motive listed as an element of a crime. Having said that, if there is no motive why someone would commit a crime, I think it really plays to that standard of evidence that we started talking about at the beginning of this chapter. How can you find someone guilty beyond a reasonable doubt if you can't see why they committed the crime? I think the absence of motive really goes to the standard of evidence, but it is not technically part of the crime. You may never know why some people do things, but if you have enough evidence they did it, then motive becomes less important. Okay, so these are elements that may be essential. We can look at state statutes that can talk about things you've got to know, like proof of harm or the age of a victim, because, for example, you'll have different statutes that say it's assault on a child under 12, or gender can be important, or identity can be important. You got Actus, Reus, you got Mens Rea, you've got Sinister, and sometimes you've got possession as something to talk about. We'll hit that a little bit more later in the class. We will talk about drugs. We're going to move on now, though. We're going to talk about that strict liability, which I had introduced. Modern legislatures, as I said, by the 20th century and into the 21st century, modern legislatures are less focused on why people do things. They're less focused on knowledge and intent and more focused on did you do it. So it is very common that a law says, I don't care what your state of mind is, I just care did you do the physical act. And these are typically called strict liability crimes. Knowledge of the act is unlawful is not required, and knowledge of what you're doing is not required. So traffic laws, as I said, are common examples. Laws on purity of food, sale of liquor, hunting laws, protecting children. Most narcotic offenses are strict liability offenses. Sometimes we don't call them strict liability offenses. In North Carolina we tend to, but sometimes you'll hear the terminology regulatory crime. So the state does not prove intent here. If you go on trial for speeding, the state of North Carolina is not going to prove that you got in your car and intended to speed. It's not going to prove a motive for speeding. It's not important. They're just going to prove you were driving 75 in a 55. All the government proves here is the act, the actus reus. Now, proximate cause, some other material elements. So think about this scenario. Let's suppose that I shoot someone, and unbeknownst to me, they have a condition, or say a hemophiliac, which is someone that lacks clotting factors, and if badly cut or bruised, will tend to often bleed to death. So I shoot someone in the chest with a gun. The bullet penetrates the chest, and I'll even say that a normal person without hemophilia probably would not have died, or maybe would not have died. But the fact that he was a hemophiliac meant that when I shot him, he bled and died very quickly. So some people would say, well, what killed him? It was the hemophilia that killed him. Or was it the bullet? And this is where we get into the idea, what is the proximate cause of death, or the proximate cause of injury? So typically we look at certain time differences. In many jurisdictions, we have what's called a year and a day rule. If you injure someone and they survive a year and a day from that injury, then their death cannot be said to be proximately caused by the injury. Often this proximate cause is self-evident, but if there is an issue, it can be raised at trial. It can be left as a matter for the jury. Now, presumptions. So presumptions are facts that are assumed. Okay, sometimes assumption is another term that's used here, but there are really different types of presumptions. There are irrebuttable presumptions and rebuttable presumptions. There are also inferences. So a presumption is something that if one thing is true, you can presume another. Inference says, well, if this is true, maybe this other thing is true. So if I have blue eyes and my child has blue eyes, there's certainly an inference that that is my child. Now, if a child is born to me in wedlock, under the law, there is a legal presumption, since I am the father, the husband, and the mother gives birth, I'm married to the mother, the presumption is a rebuttable presumption, that is my child. One of the big presumptions that exists is sanity. We presume that people are sane. We presume that people are competent. If that is challenged, the presumption of sanity is challenged, then this is one of those points where we can legitimately shift the burden to the defendant. Having raised the issue, he raises the defense of insanity. The burden now shifts to the defendant to rebut that presumption of sanity. All right, I referred to this before, the year and a day rule. The general rule is that if a victim doesn't die within a year and a day of a physical assault or altercation, then they were not proximately killed, and therefore you couldn't charge murder by the assault that occurred. Now, this was a very old rule, and what has happened gradually in the past 20, 30, 40 years in the United States is state by state, often by statute, have abandoned this rule. I would say in North Carolina it is very probable, and I can't answer honestly because I haven't looked. It is very probable that if you were to have committed a crime and someone died 13 months later, more than a year and a day, you would still be charged with a homicide. Okay, that's year and a day rule. Don't tend to see that too much. Let's talk about possession, because that was one of the things I said I'd get back to. All states make possession of certain objects criminal offenses. Now, you're probably leaping immediately to drugs, and that is certainly the most commonly charged possessive crime. Now, there's two ways that we will have possession as a crime. Actual possession and constructive possession. Actual possession means that you have, we'll say cocaine. You have the cocaine in your pocket. You physically possess it. Constructive possession, the cocaine is in the glove compartment of your car. Now, it's not physically on you. You don't have actual, but you have constructive possession or control over it. Possession is one of the rights of ownership, but I don't need to prove ownership. So if you catch me with cocaine and I say, well, it's not mine, it's Fred's, it's not a defense. It becomes a little bit more of a defense if we're talking about a constructive possession issue, but not much of a defense at all. All right, I was mentioning presumptions before. So mandatory presumptions are usually referred to as irrebuttable or conclusive presumptions. And you got to be a little bit careful if they try to shift some element of the crime from the prosecution to the defense. So a mandatory presumption that said, if I catch you in a store after hours, you are guilty of embezzlement. Courts would strike that down. But a presumption of law basically has evidentiary value more than it's an absolute rule that has to be followed. If we look at a presumption that you could rebut, one of the ones I mentioned was the presumption of innocence. Yes, you are presumed innocent, and you are presumed innocent until proven guilty irrebuttably. But once you are guilty, once we strike out that modifying clause, that presumption of innocence ends. So on appeal, for example, if you've been convicted on appeal, you have no presumption of innocence on appeal. That presumption of innocence is only irrebuttable at trial until conviction. Then it disappears. Okay, so the presumption of innocence places the burden of proof in criminal cases on the prosecution. The prosecution must prove each and every element of whatever crime we're talking about. So if we're talking about statutory rape, prosecution is going to have to prove that there was sexual contact between someone who is of age with a minor. And in North Carolina, we have rules about how many months apart you are and how young the child is. The younger the child and the bigger the age, or what's sometimes called the delta, the difference between the child's age and the person committing the sexual assault's age, the more strenuous the penalty. So a prosecution would have to come in and it would have to prove how old the child was and how old the perpetrator was. Now notice, one of the things you don't have to prove in statutory rape, and this brings up, I think, an interesting point to help solidify some things in your mind, is you don't have to prove that I know how old the child is. My knowledge is not necessary. If I meet someone who is underage and I sleep with them and they told me that they were 18 and they looked 18 and I believe they were 18 and they had a fake license they were 18. So I had no evil mind here. I had no mens rea. Not a defense. It's a strict liability crime. Okay, your book offers some thinking points to different situations that might apply to decide if you would bring charges against a driver of one or more of these cars. So you can look at each scenario and discuss, is there the physical act, is there the mental state of mind, and is there the knowledge, the signature for each scenario? And what would you charge? So we'll talk a little bit about these specifically for North Carolina. So, a man suspects his wife is having an affair. Okay. He grabs his camera and his gun and follows the woman. He finds her leaving a man's home. As she's walking to her car, the husband aims his car at her directly, accelerates the gas pedal to the floor, and strikes her, leaving her dead. He goes home and goes to bed. Okay. Did he commit the physical acts? We're going to assume that she dies. Did he commit the physical act? Yes, he did. What was his mental state? Well, he had discovered infidelity. He believed. Okay, so in some states, you might try to prove that this was temporary insanity. It's a term, it's really not used that often anymore. I don't think it'd work because you can show preparation and planning. So if you can show that he got the gun but decided to use the car, the gun hurts him. He's got the camera. He's trying to prove infidelity. So again, motive, not important here. But if I tell you he thought that she was cheating and she was leaving the motel, the man's home, then the motive, and the jury's probably going to believe, yeah, he intended to run her over. So I think you have got a first-degree murder charge there in North Carolina, at least. A man has had 3 heart attacks, and as a precaution, a cardiologist orders his driver's license revoked. However, he's got no way to get cigarettes other than drive. On the way to the store, he has a heart attack, wrecks the car, kills the other driver, and we'll assume he survives. Okay, he didn't set out to intentionally kill. Okay, we can look at the physical acts. He got behind the wheel of the car. That car was involved in an accident when he lost control. Okay, why did he lose control? He lost control because he had a heart attack. Was the heart attack under his control? No, it wasn't. But did he have knowledge of the heart attack? Well, yeah, he had knowledge that it was dangerous. So at this point, if we go back to that chart, and I'll scroll back through this real fast. 1 second. You'll recall this kind of graph here where they went up. Okay, if you look there, and you should see an arrow in a second, criminal negligence or recklessness. I mean, he didn't have specific intent. I don't think you can charge first-degree murder. The question is, was he reckless enough or criminally negligent enough? So typically in a lot of states, this would push that charge to a manslaughter. He didn't. Maybe an involuntary manslaughter, maybe, and we're going to look at the elements of the homicides when we get to homicide, so I don't want to spend a lot of time going through all the elements, but I don't think you've got a first degree or a premeditated act, so you're going to have one of the manslaughters most probably here. All right, let's go to 3. Man is put on beta blockers to reduce the chances of having a heart attack. He has blocked arteries, but does not elect to have surgery. The prescribed medicine makes him have less energy. He does not like it and therefore does not take it. On the way back from picking up his son's college roommate, he has a heart attack and wrecks the car. He kills the roommate as well as the driver of the car he hit. Okay, so this isn't a cardiologist telling me he can't drive. It's a cardiologist saying he's at risk of a heart attack. There is medicine for him. He doesn't take it. On the way back, he has a heart attack. So here's the question. And you can see how this is really pushing the proximate cause. Did he intentionally kill? No. So this was an accident. It was. If he had never been to the doctor and had this heart attack, just out of the blue, there would be no issue of liability here. He had some knowledge that he had heart disease. He knew that his arteries were blocked. But decided not to have surgery. And I think that's a reasonable thing. Surgeries are dangerous. People die from them. Maybe he couldn't afford it. Okay. He did have energy that reduced his energy and didn't like it. I mean, medicine has energy doesn't like. Here he's got some issues. Again, I think we're pushing this way down that scale of liability. I think we're pushing it down to something like more a civil issue perhaps, but certainly just barely over the line into the criminal. It's certainly not a premeditated act. Okay, so let's look at this last one. A man is driving home from work one morning, he's driving, has a mild heart attack, crashes into another car, 3 people are injured. No one's taken to the hospital, but one dies a week later of a stroke. If he had no knowledge of the heart attack, yes, he committed a physical act that resulted in the death of other people. No, it wasn't with intent. So I think there's no liability here at all. If you can't show negligence, recklessness, knowledge, any of those things, then yes, people die, but not in all cases are there criminal trials. So we'll probably talk about these in class if you're in one of the seated classes. If not, I wanted to go over them with you. So that's about a 40-minute lecture. It's about how long I like for these. I think applying these will be more interesting when we get to specific crimes, and when we get to the specific crimes in North Carolina, for example, I will probably focus quite a bit in the homicide statutes. So, you know, there are a number of different homicides that I would look at, some which are pretty clear. So I'm just going to give them to you quickly because I do have about 5 extra minutes here. So if you look at first-degree murder, and you would find that laid out, by the way, if you want to take a look, in North Carolina General Chapter 14, North Carolina General Statutes, Chapter 14, Section 17. You have to kill another living human being with malice and specific intent. Although there are alternatives. You can kill someone by poison, I think it's ambush, or lying in wait it's called, imprisonment, starvation, torture, or, and this is where that murder felony rule is triggered, if you were committing a serious felony, and that includes things like robbery, sex offense, rape, arson. Also, believe it or not, the General Assembly a few years back added nuclear or biological or chemical weapons of mass destruction. That'd all make it a first degree. And you can see that in most of our scenarios, with accepting the first one where he points a car at someone, not a first degree. Now, second degree murder is a shorter offense in North Carolina. You kill another living human being with malice. That's all that's required. And that makes us really go in and learn what malice is, which in North Carolina is defined really as an ill will or hatred. So in the cases with the car, with the exception of the first one where he intentionally did it, you see there's an absence of malice. That really kicks us into the manslaughters for most of it. So we have voluntary manslaughter, where you kill another living human being without malice. So you can see how that is pretty common. And then you've got involuntary manslaughter, and that's the one I think that, particularly scenario 3, you would look at, where you kill another living human being by an act that is not a felony and is not ordinarily dangerous, or the act you do is negligent or is an act of omission. So those are the 4 we would look at here. You would look at the first-degree murder charge, the second-degree murder charge in North Carolina, the voluntary manslaughter, the involuntary manslaughter. And I would say that you do have, you also have theoretically death by vehicle, but I don't really think it fits most of the statutes here that we would talk about. Most of the death by vehicles, the felony death by motor vehicle would be if you were impaired. There's also an aggravated felony, but possibly a misdemeanor death by motor vehicle. That might apply to one of these. You have to be violating a law, and you have to be the proximate cause of death. I would imagine theoretically crossing the double yellow line to hit these people, however you did it, you're under statute. But I don't think misdemeanor death by vehicle would fit very well. And in fact, the motor vehicle crimes are up in Chapter 20, not in Chapter 14. Okay, keeping it under 40 minutes. I will talk to you all in Chapter 4 next. Have a good night.